Dear Congress, I am writing to express my deep concern regarding the crisis surrounding reproductive rights following the overturning of Roe v. Wade, and to highlight the unconstitutional nature of many state laws enacted since. These laws undermine the protections provided by the Fourth Amendment, which guarantees individuals' rights to be secure in their persons and thus infringe upon women's rights to health, safety, and welfare. Those are elements that are inherently tied to the concept of persons in Amendment 4. Abortion is a critical component of health care, and denying this right strips women of the protections they are entitled to under our Constitution. It is important to recognize that relying on the Fourth Amendment is superior to the precedents set by Roe v. Wade. While Roe was based on the right to privacy implied under the 14th Amendment Due Process Clause, the Fourth Amendment directly addresses the security of persons in their own bodies. This makes the Fourth Amendment a stronger and more explicit foundation for protecting the right to health care, including access to abortion. Unlike Roe, which was overturned after decades of political challenge, the Fourth Amendment's protections are foundational and cannot be easily dismantled by state laws or shifting judicial interpretations. The laws enacted by individual states following the Roe decision are inferior to the foundational rights established by the Bill of Rights, which is superior law. As part of the Constitution, the Bill of Rights takes precedence over state-level legislation, particularly when such laws infringe on the fundamental liberties it guarantees. The 10th Amendment allows states to enact laws, but it does not permit the violation of constitutional protections. These ad hoc state laws, driven by personal bias and political motives, should be deemed unconstitutional and illegal for undermining the inalienable rights of women. In considering the gravity of the situation, we can draw a parallel to the Vietnam War, where the U.S. lost over 54,000 soldiers over several years. In comparison, we have already seen an estimated 60,000 women raped since Roe v. Wade was overturned a year ago, 26,000 of them in Texas alone. If left unchecked, projections indicate that within 5 years, the number of victims could exceed 300,000. This alarming forecast highlights the urgency of legislative action to restore protections for women and safeguard their health and well-being. Additionally, these ad hoc state laws will disproportionately impact young women, many of whom are between the ages of 11 and 16. These children, too young to raise children themselves, are forced into traumatic motherhood, which will have severe long-term consequences for both the mothers and their children. Children born into these circumstances often face unstable family structures, lack of father figures, and little sense of identity or belonging. These social deficits could lead to greater crime, civil unrest, and instability in our society in decades to come. It is clear that this issue extends far beyond individual victims. It is a crisis that affects our entire social fabric. Further, we must consider the rapist in this equation. Are these men being held accountable? What is the rate of conviction and prosecution for such heinous crimes? The lack of justice for these victims only compounds the trauma they face and underscores the need of robust legislative reform. At the heart of this crisis is the need for the health care policy grounded in superior protections of the Bill of Rights. The rights of persons, as defined in the Fourth Amendment, must be fully understood, respected, and applied to safeguard the health and dignity of all women. Congress must have the courage to defend these constitutional protections and enact meaningful reforms that protect women's rights to health care, including access to abortion. The future health and welfare of our country depends on the actions we take now. Sincerely, Orion K.